Hello, I'm Judge Elaine Gordon, and I'd like to welcome you to this section of Case Flash, the Rules Edition. In this section, we're going to be reviewing the changes in the practice book appellate court rules, some of which we will be discussing in detail, and others of which you will find reviewed on some of the PowerPoint presentation that accompanies this video. So Sam, maybe you'd like to take 61-10, which opens up a whole new world of articulation.
Sure. 61-10 deals with the responsibility of an appellant to provide an adequate record for review, and this is one of the most important sections in the entire practice book for appellate lawyers, because getting a proper record for review is crucial as an appellant. A lot of claims historically, the appellate court doesn't even review them because they say the record isn't adequate, and one of the big hooks for that has been that the trial court decision was unclear, should have been articulated. The appellant didn't move for an articulation, didn't follow up with a motion for review of the action on the articulation, and so, sorry appellant, your claim isn't going to be reviewed. And the Supreme Court actually dealt with this in some detail in a recent case, talking about literally hundreds of cases in between 2007 and 2010 that weren't even reviewed because of a defective or a lacking articulation. And so this new 61-10 deals with that. It says the failure of a party on appeal to seek articulation pursuant to 66-5 shall not be the sole ground upon which the court declines to review any issue or claim on appeal. Sole ground. So it's not clear exactly what that is going to mean. My guess is that it's going to mean that the forfeiture sanction that applies is going to be loosened a little bit, but I think the appellate court is still not going to review certain claims or review them in a different way, saying that every reasonable presumption in favor of the trial court correctness of the decision is going to be assumed. And I think that's going to get around some of the lackings in an articulation. And I also think that the appellate court still isn't allowed to speculate. And so I think that to the extent that the lack of a clear decision requires the appellate court to speculate, that the appellate court is not going to do that, and it's going to find against the appellant for that reason.
So as an appellate practitioner, you think this is a good change?
As an appellate practitioner, yes, I do. Just because there's so many cases where they wouldn't even get to your issue. You brief the issue, you think you think the decision is clear, and then the judges in the appellate court don't think it's clear, and rather than send it back to make it clear, the issue doesn't get resolved. And so, just out of basic fairness to the appellant. The issue is more likely to get resolved now, and I think that's a good thing.
But doesn't this slow down an already grueling, slow process? If you read the last part of the section, they've added this whole new procedure about sending the matter for articulation at the end of argument and then going through this whole procedure with the trial court about filing supplemental briefs and supplemental exhibits and supplemental transcripts. At what point do the people get their answer?
Well, it's going to be interesting to see how it's actually applied, because it says that the appellate court may send it back for an articulation. It doesn't say it shall send it back for an articulation, even if an articulation might have been necessary. So we'll see how often it actually happens. It also I think helps deal with the back and forth that's been going on now for a long time, where the trial court doesn't render a clear decision. A motion for articulation is filed. Goes back and forth with the trial court in the appellate court, trying to get an answer to a specific question, and you never actually get an answer, and that can go on for quite a long time. To the extent that this helps bring that to a close, that would facilitate the movement of some appeals. But I think you're right. I think there's a concern that you have this long appeal, and at the very end of it, what do you have? You have an order that the trial court judge articulate. Now we're in year 4 of the case.
One of the things that's irksome, I guess, to judges about articulations is that they come so long after you've had the trial. And now we may be getting them even longer, or they may be getting them, I should say, even further out in time, And, it forces you to go back and read the whole transcript, try to reconstruct exactly what you were thinking and when. And, when you're dealing with a high volume docket, that's not so easy to do necessarily.
Yeah, and even though the rule says the parties can submit transcripts and supplemental briefs and exhibits, I'm not sure it's a tough use of judicial resources to go back and refocus on something you did 3-4 years ago and figure out why you did it, and then you can't change your decision, but you have to articulate your decision. That's tough. That's tough for a judge to do.
And I note that the rule doesn't specifically allow the trial court to take additional evidence. So you can't go back to the trial court and put on new witnesses or the same witnesses to try to illuminate the trial court as to what the issues are.
Yeah, it's silent on whether you should be able to put on evidence, but the case law suggests you can't put on new evidence. You're supposed to articulate based on what already happened. And it does allow you to put in transcripts, but it doesn't say anything about evidence. I mean, where it does talk about evidence is 66-5, the motion for articulation and motion for rectification, says that a trial court can ask for evidence, in resolving a motion under 66-5. Now, I've always read that to mean a motion for rectification, not a motion for articulation, even though it's under the same section. But you're right, the word evidence is not in 6110.
And the 61-11 has also had a pretty dramatic change. It's the list of factors to consider when terminating automatic stays in family matters. And this comes up in virtually every family appeal. Which of you wants to take the first stab at this?
Well, I think that
I guess it's Alan.
I think that what 6111 tries to do is it tries to codify two cases. The first thing it does is it codifies Yontif versus Yontif, which is a 1981 case, by saying in a practice book section that there are certain family cases that an automatic stay of execution on appeal will not exist. Cases such as custody, child support, alimony. 61-11 also adds 46B15 applications, exclusive possession appeals, puts the automatic orders back in place while an appeal is pending. And then the second part is 6111 also codifies Griffith Hospital, what are known as the Griffith Hospital standards, from a case called Griffith Hospital versus Commission on Hospitals and Healthcare, which is a 1985 case. And as I read 6111, the Rules Committee essentially watered down some of the factors to make it easier to get relief from stay in cases where there are appeals pending. For instance, under 6111C, you are no longer required to prove the substantial likelihood of success on appeal, which was a requirement under Griffith Hospital. Additionally, under Griffith Hospital, you were required to prove an irreparable injury while the appeal was pending. Now you only have to prove potential prejudice. So I think what's happened is they've made it easier to get a termination of stay. The question is whether the types of stays that are available in family cases are worth being terminated. It would seem to me that the only thing left are orders under property division under 46B81. And it really narrows the issue for the trial court as to whether that stay is going to be terminated.
I think family cases are unique, and I think that this does carve out from Griffith Hospital the kinds of factors that a trial court really should be looking at. I mean, these parties have to survive, and not just the parties, but their children. Their children actually make it into the practice book here. It's not just the needs and interests of the parties that matter; it's the needs and interests of the children. Even other persons affected by the order. I'm not sure who those other persons are, but they even made it into this new section. And so I think this is just a recognition that family cases are different. That there are a lot of relationships that are ongoing. The case continues to develop, and there's a dynamic to family cases that may not be there for a contract case or a tort case or some other case. So I think that's what the practice book is trying to do here. And I also think that the last tagline, that the court consider the equities, that opens it up wide. I don't know exactly what that is going to mean. I don't know what restrictions are going to be on a trial court considering the equities. And I don't know what you're going to say in a motion for review when the trial court acts on this and decides one way or the other, and then you file a motion for review with the appellate court saying the trial court did it wrong. If the court ruled that under the equities, this is what the trial court wants to do, I'm not sure what you're going to say about that in a motion for review.
I think that, I think that I like this change. I think that it's intellectually honest. I think that it kind of takes the Griffith Hospital criteria, which came out of a civil case, which we were applying in family situations, and says, look, this is essentially what we were really doing, and these are the things that we're looking at, or we should be looking at in the interests of the parties and their families, because we don't want the appellate process to leave them in financial ruin, or to leave them with nothing left that's going to be divided, and they've taken all of the things that were missing for family cases, and I think put this in. So I think the people who drafted this did a really nice job.
I think that this is actually one of the most important family sections in either the statutes or the practice book, because it has such an important practical effect. A stay pending an appeal is a big deal, because it could go on for a long, long time, and often these financial orders assume that a party is going to get an equitable division, and that certain things are going to happen, and when they don't happen, it has a real practical effect on not just the parties, but on their minor children.
The other practical effect, I think, is by including the automatic orders within the state provisions, I think it closes a loophole that many of us have either used or fought against for years since the automatic orders have been in place. Because right now it's simply reading 25-5 of the practice book. Once the case goes to judgment, the automatic orders theoretically go away. So the question is, does the case go to judgment when the court enters its decree or when the appellate process is concluded? And I think the addition of 6111 of the automatic orders closes that loophole completely.
Yeah, and that was an important loophole to close because, especially when one person has control over the assets, this is an important loophole that had to be closed.
Well, I think the closing of that loophole is a good place to end our Case Flash Rules Edition presentation today. And I am reminded that every time there are changes to the practice book or to statutes, litigation follows as people try to figure out what the rules actually mean. And so we look forward to being able to present some Case Flash editions that will explain the rule changes into the future. Thanks for joining us.